Okay. Well, I have to say, although this is not the first event that we organized together with MGIMO from Moscow, this is the first this big event, and I believe this is just the beginning of the. I'm sure, in fact, this is just the beginning of a cooperation which will be certainly very fruitful in the future. Okay, thank you. Now I give the floor to Professor Aleksandar Gajić from the University of Belgrade, who is at the same time the chief legal advisor of the Ministry of Foreign Affairs of Serbia.
Good morning to everybody. Of course, since the conference is in English, I will speak now in English language, but at the beginning I would like to say something in Russian. Особо хотела сви поприветствовать и выразить благодарность нашими коллегами из Московского государственного института международных отношений за инициативу по организации данной конференции. I have the honor of being the keynote speaker at this conference designed to the very specific and very actual issues of international law. This conference is devoted to the international regime of national resources of celestial bodies that is still developing and confronting variety of divergent interests, particularly among and between major space actors and developing states. As a keynote speaker, having in mind that the other participants will deal with more specific issues and the practice of states in this developing field of international law, I will focus primarily on some more or less general issues that concerns the directions of the development of international space law. We are witnesses to the progressive development of space technology and various forms of utilization of space resources since the Sputnik, the first artificial Earth satellite, was successfully launched on 4th October 1957. Significant development of the space law occurred since late 60s and 70s as a new, very specific field of international public law. We come to the point that currently the most actual and intriguing topics concern legal regime of exploration, exploitation, and utilization of space resources, resources of the moon and other celestial bodies, but also prevention of armed race in outer space. However, exploration has not yet started, but it seems feasible, and those activities are followed by the many legal uncertainties and the need for further development of the very wide legal field. At the very beginning, I will briefly outline the main UN bodies that bear primary responsibility and merits the development of international outer space law. Today, all of the issues of international space law are under consideration in the United Nations. The main UN body with the merits and specific responsibilities for outer space affairs and legal development of the international space law are undoubtedly the Committee on the Peaceful Use of Outer Space, set up by the General Assembly of the United Nations back in 1959. Since its establishment, it grows up to one of the largest committees at the United Nations with 102 members. Today, this committee has two subcommittees, the Scientific and Technical Committee and the Legal Subcommittee, both established long ago in 1961. The Committee on Peaceful Use of Outer Space reports to the fourth committee, known as the Special Political and Decolonization Committee of the General Assembly. However, outer space affairs are matters of concern of other UN bodies, particularly since there is a separate UN Office for Outer Space Affairs. Also, today is a particularly actual and important open-ended working group on reducing space threats through norms, rules, and principles of responsible behaviors that was formed last year with primary topic named Prevention of Armed Race in Outer Space. I have to note that the development of international space law was not entrusted to the International Law Commission, dealing exclusively with earthly matters. Those forums, General Assembly of the United Nations, and particularly the Committee on Peaceful Use of Outer Space, are appropriate forums for the discussion concerning creation of legal regime of celestial bodies and its resources. While it is beyond doubt that space-related activities must be in accordance with the UN Charter, what is confirmed in number of resolutions, reports, and other documents, it is also necessary that United Nations be the center for harmonizing the actions of states in relation to outer space and further development of international space law. The international space law is treaty-based law. I will not go through the history of its development, but there is a need to emphasize the value of the treaty on principles governing the activities of states in the exploration and use of outer space, including the moon and other celestial bodies, known as Outer Space Treaty, adopted by the General Assembly of the United Nations on 19 December 1966 and entered into force following year on 10 October 1967. Outer Space Treaty is a basic treaty and cornerstone of the contemporary international space law. This treaty is widely accepted, and as today it has 122 parties. Principles of this treaty are universally recognized, even by those states that are not parties to this treaty, such as the Republic of Serbia. And it seems that there are strong arguments that they are now part of international customary law. There are also 4 other treaties adopted by the United Nations General Assembly and many other agreements, and some of them I will address in my further presentation or during discussion. I would like to note that just listing United Nations General Assembly resolutions and other documents that are of importance for determination of the principles and rules of international space law would consume almost all time reserved for introductory discussion of the issue. I will now focus on the main issue that concerns today's topic. I would like to start with the general conclusion that the legal regime of outer space and celestial bodies still have to be developed. In other words, it is insufficiently developed. Maybe the first disputed issue is what is the area of international space law, particularly what is the boundary between airspace and outer space. Some states are of the view that the boundary needs to be fixed by international treaty, but the other claim that it is not strictly necessary. Boundary certainly exists somewhere, but the question is at what altitude. Some authors propose 80 kilometers, some states claim 100 kilometers, and some 110 kilometers above the sea level. This topic is constantly discussed by the committee since its establishment, and final solution is not yet visible. The issue is still on the agenda of the committee. Legal status or regime of the moon and other celestial bodies, and also their resources, is surrounded by many, let's say, legal difficulties that need to be resolved in the near future. While the Outer Space Treaty provides a set of principles that are clear and universally accepted, they are far from creating a comprehensive legal regime. Of course, I will not reproduce here the whole text of the treaty, not even all principles, just in brief. Outer space and celestial bodies are area outside national jurisdictions, not subject to national appropriation, by claim of sovereignty, by means of occupation, or by any other means. Exploration and use shall be carried out for the benefit and in the interests of all countries, irrespective of their degree of economic and scientific development, and shall be the province of all mankind. They are free for exploration, and there is a freedom of their scientific investigation. The Outer Space Treaty provides that the moon and other celestial bodies shall be used by all states to the treaty exclusively for peaceful purposes. the establishment of military bases, installations, and fortifications, the testing of any type of weapons, and the conduct of military maneuvers on celestial bodies shall be forbidden. While it is clear that celestial bodies cannot be subject to national appropriation, the legal status of the Moon and other celestial bodies are not sufficiently clear. The principles of the Outer Space Treaty creates just a general framework for further development of the legal status of the Moon and other celestial bodies. In that context, the concept of the common heritage of mankind should be discussed. This political and legal concept was firstly mentioned by Ambassador Pardo and Kuka in 1967, and concerning areas that are not easily accessible, and the areas that for their exploration significant technology and resources are required. While this concept is not even mentioned in the Outer Space Treaty, its basic characteristics are at least insufficiently clear. Agreement governing the activities of states on Moon and other celestial bodies adopted by the General Assembly in 1979, also called the Moon Agreement, made proclamation of the Moon and other celestial bodies as the common heritage of mankind. However, the Moon Agreement entered into force only in 1984, when only 5 states deposited instruments of ratification. Today, this treaty has only 18 parties. That is clearly insufficient to consider the principles and rules of this treaty as universally recognized. States that are major space actors are not parties to this treaty. The concept of the common heritage of mankind entered into international arena in late 60s and 70s, and in order to understand it, we need to understand the political context of that time. That is the time when the United Nations was preoccupied by the interests of developing countries, particularly countries that emerged from the process of decolonization, emphasizing the strong element of solidarity between them. This concept found its place only in the United Nations Convention on the Law of the Sea, and some of its aspects are to be present in the legal regime of the Antarctica and, of course, in the Moon Treaty. However, in the Law of the Sea Convention, the area, that means the seabed beyond the national continental shelves, was proclaimed as the common heritage of mankind, and the institutional mechanism was established. The United Nations Convention on the Law of the Sea puts the exploration of the mineral resources of the area under international administration, international organizations named International Seabed Authority. However, this concept was significantly changed by the 1994 protocol, since some of the solutions was not universally accepted. However, the derogation of the very proclamation of the area as a common heritage of mankind is prohibited by the treaty in an attempt to create the new cogent regime. Common characteristics of the area and the outer space is that those areas are not easily accessible, and that for their exploration and exploitation, enormous resources and very demanding technology are simply necessary. The Moon Treaty provides in Article 11 that the Moon and its national resources are the common heritage of mankind, which finds its expression in the provisions of this agreement. Provisions concerning the Moon and its resources are also applicable to other celestial bodies. Namely, the Moon Treaty provides that the provisions of this agreement relating to the Moon shall also apply to other celestial bodies within the solar system other than Earth, except insofar as specific legal norms enter into force with respect to any of these celestial bodies. It is not necessary to go in every detail concerning solutions provided by the Moon Treaty, but for the topic of the present conference, it seems that the following provisions of the Moon Treaty is of particular importance. In Article 11, it is provided that neither the surface nor the subsurface of the Moon, nor any part thereof of national resources in place shall become property of any state, international, intergovernmental, or non-governmental organization, national organization, or non-governmental entity, or of any other national person. State parties have the right to exploration and use of moon without discrimination of any kind on the basis of equality and in accordance with international law and the terms of this agreement. Since the Moon Agreement does not contain the necessary solutions for implementation of such a regime, it is further stipulated that state parties to this agreement hereby undertake to establish an international regime including appropriate procedures to govern the exploration of the national resources of the Moon as such exploration is about to become feasible. One of the main purposes of the regime established by this treaty is that an equitable sharing by all states parties in the benefits derived from those resources, whereby the interests and needs of the developing countries as well as the efforts of those countries we have contributed either directly or indirectly to the exploration of the Moon shall be given special consideration. While the treaty has only 18 states, it cannot be considered as universally accepted. No major space actor is a party to this treaty. It seems that a particular problem is not in the prohibition of national appropriation of areas of the Moon and other celestial bodies, but about the management of the resources in question and its ownership, particularly when they come to the Earth. Before the Committee of the Peaceful Use of Outer Space, it is frequently emphasized that it remained unclear whether non-renewable space resources such as minerals and water could be subject to ownership regime, and also what are the parameters of the legality of its commercial exploitation. Special working group was formed on legal aspects of space resources activities, and it is noted that in the last report of the committee that there is high level of interest among delegations. But of course, there are no ready-made solutions. Some delegations expressed the view that the regulatory framework should be completed before carrying out actual activities for the exploration, exploitation, and utilization of space resources. However, there is also a view that there is neither a need nor a practical basis to create a comprehensive institutional regime for space resources utilization activities as humanity was in the earliest days of space resource exploration, exploitation, and utilization. Even if we consider that the Moon and other celestial bodies are a common heritage of mankind, further development of this concept requires some institutional mechanism. Having in mind the nature of outer space, as well as the very characteristics of international space law, it seems that the only viable solution is that this mechanism should be created under umbrella of the United Nations. In one introductory note, there is no enough time to consider all aspects of the regime of celestial bodies and its resources. However, one consideration needs particular attention. This is emphasis on the interests of all states, particularly developing countries. What certainly is important issue in development of the legal regime and creation of some international administration. There is not many major space actors, and most of the states have not enough resources or technology necessary for the exploration and exploitation of the resources of the Moon or other celestial bodies. While provisions of this treaty and various resolutions demanding respect for interests of all states, and particularly developing states, concrete interests are still not articulated, or at least it is in the very early stage of its articulation. In one word, in order to provide some solid legal framework, those interests must be subject to comprehensive discussion before the activities of exploration starts. One of the topics in international space law that needs particular attention is that field of international law does not allow too many particularities. While particularisms form the predominant part of international law, international space law by its very nature needs to be built on universally recognized principles and rules. In that context, the so-called Artemis Accords concluded by the US and other NASA participants in the Artemis Outer Space program provoked a debate whether those accords are in line with contemporary international space law. While the Moon and other celestial bodies are not subject to national appropriation by proclamation of sovereignty or in any other manner, they are territories outside national jurisdiction open to use of all nations. There is a need for the establishment of the efficient international administration. However, today, there are no official proposals on the composition and the method of work of that international administration. The time for my presentation is clearly leaking, and I would like to stress the issue of responsibility for space-related activities, including those concerning outer space national resources. International legal framework established by the Outer Space Treaty is more than clear. In accordance with Article 6, states shall bear international responsibility for national activities in outer space, including the Moon and other celestial bodies, regardless such activities are carried out by governmental agencies or by non-governmental entities. It is clear duty of the states to assure that national activities are carried out in conformity with international law. In order to ensure this, the Outer Space Treaty obliged states that the activities of non-governmental agencies, private companies, private agencies, etc., in outer space require not only state authorization, but also continuing monitoring by appropriate state authority. In one word, private companies may not on their own conduct any of the space-related activities. It is reserved for the states that are only responsible for outer space activities. This principle is of particular concern today when many private companies or non-state agencies are heavily engaged in various space programs. Also, Outer Space Treaty is very clear that if some international organization conducts activities in outer space, responsibility is not only on that organization, but also on the states that participate in that organization. This concludes my introductory presentation, and
okay, well, thank you. Thank you, Professor Gajić. Well, now I have the pleasure and the honor to announce and to invite our dear guests from MGIMO University. That is Professor Dr. Aleksandar Vylegzhanin, who is the head of the International Law Department of the MGIMO University, and Assistant Professor Dr. Mariam Yuzbashyan from MGIMO University. The title of their intervention is Status of Natural Resources of Celestial Bodies, addressing the new legal practice of states. Professor Vylegzhanin is here with us in Belgrade. Professor Yuzbashyan will take part online. That's the young lady whom you see on the screen. When I said our guests, that's a technical term because this institution, this place is also their home, and I hope they feel so. And just for technical reasons, because those technical gadgets are here in front of me, Professor Vylegzhanin and I will have to swap seats, so he will come here and I will move somewhere. Okay, thank you.
It's certainly an honor to be at this international conference, in Belgrade University, Faculty of Law. The conference is devoted really to the future practical questions, as Professor Gajić have already noted, and I fully agree with him. In fact, the legal issues of natural resources regime are to be addressed before practical issues already are a reality. Just we can compare with marine living resources. If, for instance, the legal issues of the Bering Sea marine resources were settled before, then there would be no, so to say, devastation of the Bering Sea marine living resources. And this trend to have legal regime in advance to unregulated activity is already a reality in international law. For instance, we know that the Central Arctic Ocean, in the Central Arctic Ocean we have the huge area of the high seas, and in advance to practical exploitation of marine natural resources of this area, we have already agreement to stop to prevent unregulating fishing in this area. So now we speak not about, so to say, very modest value. We speak about great financial consequences of the legal regime of natural resources of celestial bodies. According to recent publications, there are asteroids, for instance, where the quantity of silver is really huge. So the first who come to this asteroid might change the economy of the world. That is a reality. That is why the conference, which was so excellently organized by Belgrade University and co-organized by MGIMO University, is really of great importance. So right now, if we look at the text of my presentation, it is devoted to status of natural resources of celestial bodies, addressing the new legal practice of state. This presentation is prepared together with my colleague from MGIMO University, PhD in International Space Law, Dr. Mariam Yuzbashyan. I would like to start with the, so to say, introductory remarks, and thank you, Dr. Gajić, that much of the legal instruments which are relevant to the topic are already addressed. But I just want to reiterate that according to the textbook published in 2007 by MGIMO University, the legal regime of natural resources of celestial bodies is regulated and will be regulated by international law. The question is, what rules of international law? Universal, or say rules constructed by some states? And that is really a very important question. As for specific universal international legal regime of the natural resources, the most important remark is, when we speak about such a regime, does it have lacunas? Is it not established yet? The use of natural resources of celestial bodies, as already noted by the previous speaker, is not prohibited, but only according to international law, as it provided by the Outer Space Treaty of 1967, as already mentioned before. So I think that when we speak about international law which is applicable to the regime of natural resources, of course we first are supposed to address the United Nations resolutions regarding this issue. And as you can see, starting to the UN General Assembly resolution of 1961, international law is applicable to outer space and celestial bodies. And according to this resolution, the celestial bodies are free for exploration and use by all states in conformity with international law. They are not subject to national appropriation. So when we speak about another declaration of the UN General Assembly, we note that celestial bodies are free for exploration and use by all states in accordance with international law. So this accent on international law is reflected practically in all documents. You cannot find in Outer Space Treaty that you might use natural resources of celestial bodies according to your national law. That is not reflected in the Outer Space Treaty. When we speak about the treaty itself, of course, it is already mentioned by Professor Gajić correctly, and practically I agree with everything which was noted. Speaking about interpretation of this treaty, the cornerstone of international space law, as already correctly noted, we think that there are a sort of two main approaches to interpretation of this treaty. The first is that the non-appropriation principle extends to celestial bodies' natural resources. That is, it is applicable to natural resources regime of celestial bodies. The second approach for interpretation is that this principle applies to celestial bodies as a whole, but does not extend to natural resources thereof. Correspondingly, the Outer Space Treaty provisions do not exclude rights on the celestial bodies, and including the extraction of the natural resources thereof. So these are two main approaches, as we could see. And the Outer Space Treaty does not have a sort of specific words regarding which of these two approaches is correct. In our MGIMO University, Professor Kolosov noted that it is necessary to have a sort of authentic interpretation of this Outer Space Treaty through enactment of a protocol or through international court's decisions relating to specific disputes. We think that in any case, the problem of interpretation of the basic document of international space law relating to outer space activities is, of course, a key question today. Now, speaking about the other agreement from these UN arrangements and there are, as you know, 5 such arrangements, but probably the Celestial Bodies Agreement of 1979 is the most relevant to the topic. So according to this Moon Agreement, as we call it, the natural resources, of course, are an object of international law only. In addition to what already have been said, and I agree with this, I would like to emphasize that according to the agreement of 1979, the use of natural resources might be in 2 forms. First, carrying scientific investigations or research. For these, states might collect on or remove from the celestial bodies samples of its mineral and other substances. They may also use mineral and other substances in quantities appropriate for the support of their missions. Of course, there are still some questions relating to abuse of rights, whether you say take 1 kilogram of these substances, and this is legitimate, no problem. But if you take, say, 1 ton of these substances, is it legitimate or not? If we pay attention to Article 11 of this agreement, of course, the principle that natural resources are the common heritage of mankind, as was correctly noted by my colleague, the mechanism of common heritage of mankind is not provided, not only by these agreements, specifically for natural resources of celestial bodies, but in any other agreement. In contrast to the legal regime of marine mineral resources. United Nations Convention on the Law of the Sea of 1982 provides the mechanism for common heritage of mankind regarding the mineral resources of the area, that is the area beyond national jurisdiction. Part 11, the specific 1994 agreement on application of this part. This is a mechanism. Everything is clear. You might call it good, you might call it bad, but this is a reality of international law. In contrast to this, we do not have such a mechanism for natural resources of celestial bodies. There is a legal qualification, but there is no mechanism. Now we pay attention to the last part of my presentation, that is the new legal practice of states on the use of celestial bodies' natural resources. And here probably is the most important part of the problem, which is already a reality. First, of course, we pay attention to the legal practice of the United States and its partner. Again, I do not call whether the practice is bad or practice is good or something in the middle. I just want to say that this is a new practice, relatively new. But such a practice was expected. It's not an unexpected event. Again, in MGIMO University textbook in 2007, Professor Kolosov already printed the future trend on the regulation of the use of celestial bodies' natural resources by national laws in absence of participation of the Moon Agreement. In fact, today we can foresee that the number of participants of this celestial body agreement of 1979 will be diminishing, but not increasing. And that is a reality. Even now, as already mentioned, it has only, I believe, not more than 20. And in contrast to the outer space treaties, the number is huge, more than 100 states parties. So we might say that we have a problem. What is agreed by the universal conventions and what is done in reality by some states through their national legal practice. And since this is a very important problem, of course, other states, not only those who have possibilities to launch, so to say, spacecrafts and be on some asteroid with silver or with gold or whatever, all states are interested in understanding what will be the future regime of exploitation of natural resources of celestial bodies. Now, speaking about the first national act, which differs from Outer Space Treaty of 1977, or I'm sorry, 67. So it's not that it is the first national law on outer space activity. Not, of course. Many states have such national laws, but it is the first national law which provide, I would say, conceptual difference in comparison to the Outer Space Treaty of 1967. And it is called here, you have it before you, the U.S. Space Resource Exploration and Utilization Act of 2015, and followed by other national laws, I would say, developing this trend. You could see them. We have the reports of my colleagues specifically devoted to national law of Luxembourg and some others, so we can have possibility to be, so to say, acquainted with the context of this law. And if we analyze this legal act of United States of 2015, the first difference is that it introduces new terminology. It introduces the term space resource, which is not provided by United Nations treaty, the basic treaty, Outer Space Treaty of 1976. You might say, well, Professor, terminology is not so important. Yes, we might say in the context, but not in this context, because when you change terms, that means that something in the Outer Space Treaty, the international obligation of the United States, might not be applicable or provide disputes. And so, according to US legislation, space resource and asteroid resource. In the UN treaty, we have only one, natural resources of celestial body, only one term. But since you introduced new terms, that might mean that there is something different. That might cause questions relating whether the outer space obligation is applicable or not to asteroid resource, for instance. And that is really important. Now, speaking about the subsequent legal initiatives of the United States, now we speak about the executive order of the President of the US on encouraging international support for recovery and use of space resources. Now, you see, the term is already reflected here. According to this executive order, the bilateral Artemis Accords between NASA on behalf of the United States and some other countries. First, they were only 7 founding member nations: Australia, Canada, Italy, Japan, Luxembourg, United Arab Emirates, United Kingdom. And then later it was the number increased, and it has only also added Argentina, Bahrain, and you see on the screen other countries. In addition, NASA signed some other documents. And what is the legal innovations provided by these international accords initiated by the United States? First, we might say that there are principles reaffirming the general provisions of the Outer Space Treaty. This is a reality. Moreover, I would say the jurists or lawyers of the United States Department worked really very hardly, and I would say professionally, in order to say that no obligation of the United States is violated by issuing national legislation and by issuing Artemis Accords, by initiating these agreements. And in fact, in a way, they are successful, since the terminology is already accepted, I would say, during the discussion within the United Nations, the Outer Space Committee, legal subcommittee. So you might see that the principles reaffirming the general provisions of Outer Space Treaty is successfully inserted in the Artemis Accords. Second, provisions of technical character on interoperability. Well, they are not reflected in the Outer Space Treaty, but nothing in the Outer Space Treaty qualify that such an innovation is contrary to this treaty. Yes, I would say they are generally in accordance with the Outer Space Treaty. Third, principles which internationalize the United States national legal approach. And that is really a danger for the interests of the majority of countries, I would say. Because, there are some words regarding the interpretation of the United States of some specific and very important provisions of the Outer Space Treaty in the interests of the United States. You might say, well, what are their interests? Their interests are very simple. That their persons, whether physical persons or legal persons, might have access to the natural resources of celestial bodies according to national legislation of the United States. As simple as that. And fourth, principles related to the use of natural resources of celestial bodies. And for instance, safety zones. These provisions are not in the Outer Space Treaty. But according to Artemis Accord, say the first come, the first served. The first come, of course, United States or its partners. And of course, they have right to establish safety zone, and that is safety zone. You cannot come to this safety zone only on the basis of special arrangement with a country which has established this safety zone. And that is already, I would say, something which is different from the wording of the Outer Space Treaty, according to which free access to any place in celestial bodies. So again, I would say that we might discuss many things, but the key question is what will be the next legal development of the legal regime of natural resources. Whether it will be multilateral, universal, that is, first of all, according to the Outer Space Treaty of 1967, whether it might be bilateral, that is, on the basis of the agreements of United States with its partners, Artemis Accord, about 30 states parties probably are already participating in these accords, and national legal approaches. For instance, if United States have already its legal way how they view the legal regime of natural resources, other states might follow the same pattern. And you know that there are such states which have technical possibilities, but what will be the consequence? Many national approaches, say United States and its partner, Russia and its partners, China, and so on and so forth. And you could see that the clashes regarding exploitation of natural resources of celestial bodies in such circumstances might be inevitable. And that is really key questions. The idea to prevent such interstate clashes, like the humanity managed to prevent interstate clashes regarding natural resources of the world ocean. This perspective, these questions are really very, very important. Thank you.
Thank you, Professor Vylegzhanin. Now we have the time for discussion. I invite all those who are either present here in this room or who are present online. Okay, you can say that, and if you have any questions, just be free to ask them, to put them. Okay, yeah.
So during your presentation, it was written that many countries are signed.
I'm sorry, could everyone please use the microphones because people are...
Yeah.
So during your presentation, it was written that some of the countries that are not that well developed are signed to such acts and etc. For example, I saw Romania, and Serbia, for example, is not signed. And why is it important for such countries that don't have that technical abilities for space exploration to be signed for it? Is it because, the way you said, the bigger countries that have technical opportunities, because they are somebody's partners, so that they don't they don't exploit their friendships, let's say, political, or is it something else?
Thank you for the question. I think that probably we shall invent such an important procedure for answering questions. First, my younger colleague Mariam Yuzbashyan, Doctor of Law from MGIMO University, might answer your question, and then probably I shall add something. Mariam, do you hear me?
day, dear colleagues. Very nice to meet you, and thank you very much for your invitation. What can I say about the Outer Space Treaty? I think it's important both for the countries that have developed technologies and as well as for other countries, because this is the act that provides a stability for the sector, both for the new ones and for those that have a history in this field. Maybe you have any more specific question regarding the potential participation of Serbia in the treaty. I would be able to provide an answer, but just as a whole question, I think it makes important to be party to the Outer Space Treaty. I have also noticed that Serbia is party to 3 other UN treaties on outer space besides the Moon Treaty and the Outer Space Treaty. The 3 treaties provide some development of the main provisions of the Outer Space Treaty. But the most important issues are also contained in the Outer Space Treaty. But from the other side, it is also important to understand that the view that the Outer Space Treaty's principles govern all activities of states, not only the states parties. It's also a point to be understood and to be discussed within the question of possible conclusion of this treaty.
Mariam, I think that the question was not about participation of Romania in the Outer Space Treaty, but probably in participation of Romania in accords, agreements of the United States. Yes.
Romania, I'm Serbia. I'm so sorry.
Yeah. Yes. So probably I might add to what Dr. Mariam Yuzbashyan has already mentioned. Probably I would say that, yes, there might be interesting question why countries which do not have technical possibilities to be on the moon or other celestial bodies, still they try to participate with the United States in this Artemis Accords. I think that the answer might be that they think that with the legal, so to say, leadership of the United States, they might be also investors in the outer space commercial activity according to the US legal approach, just disregarding the outer space treaty restrictions or obligations, and by this they might have economic possibilities to invest and afterwards to have benefits, probably. But of course, I cannot say for sure. Yeah. Thank you.
Yes. Thank you very much, Aleksandar Nikolaevich. Dear colleagues, please, I apologize for not hearing the right question. As to the Artemis Accords, if it is a political decision, yes, the United States has the practice to invest in the national fields, so as they did with the Luxembourg, for example. I presume it might be possible to do the same with other states parties to the Artemis Accords.
Mm-hmm. Thanks. Well, other questions probably.
Okay. Are there any other questions?
Tired.
I have some questions.
Yeah, sure.
May I please ask a question about the non-participation of Serbia in the Outer Space Treaty? The issue that I was trying to answer, however, it was not asked. Why does Serbia does not participate in the Outer Space Treaty, but participates in the Registration Convention and the 2 other conventions of the United Nations?
Question for you.
I think we have the right person here.
Yeah.
But Professor Gajić, thank you.
I personally think that this is, let's say, some kind of omission, because Republic of Serbia, of course, is devoted to the principles of the Outer Space Treaty. And
yes.
I must admit that in preparation for this conference, I was very surprised that we are not a party to this treaty. Namely, Socialist Federal Republic of Yugoslavia signed this treaty, I think, in 1967 or 1968, but never ratified this treaty. In 2001, 2002, we provide to the General Secretary of the United Nations notification of the succession of the old treaties, which the General Secretary of the United Nations is depository. And that treaty, of course, was not on the list because we were not the part because we are not a party to this treaty, and we were preoccupied by earthly matters, and particularly with many other problems. So the space treaty was, let's say, too far away, too far away. But I think that in the near future, some activities will be conducted in order to ratify this treaty. That's, I think, not the problem, since, as far as I know, our delegation said something in the United Nations supporting the principles of the Outer Space Treaty. You know, when we are speaking about the Outer Space Treaty, it is well recognized as universally accepted. Its principles and its rules. So this is the part also of the customary international law, and every state, in order to conduct any of the space activity, needs to rely on the Outer Space Treaty.
Yeah.
Yes, the principles that established the Outer Space Treaty are recognized by the whole community and as customary law.
It was already said.
Yeah. Yeah, I said that. Maybe there are some technical problems, or we don't hear each other very well.
Mariam, do you hear?
Thank you very much. We do. I think we do hear well.
Okay.
Thank you.
Any other questions?
Dear colleagues from MGIMO University, would you like to ask some questions, please? And for other colleagues too. We could discuss any issue, because I think, if I can say that, the discussion of the issue of the space resources regulation at the international and national level is also important in view of the development of the international space law on the whole. The United States made a trend, so we should investigate this trend and understand which consequences could be in other fields of space activities, the regulation of space activities. Would we go on the multilateral level or not? Is it possible or not? What to do to provide the safety and comfortable regime for the whole community? And is it possible also? I think the issue of resources has this impact on the whole development of international space law. That is why it might be even more important than just the economical and financial issues of space resources mining. I hope I...
Yes, thanks, Mariam, for your valuable additions. Yes, I think that, of course, we might talk more and more, but there are other speakers and other
we have some time for discussion.
Good,
we will have a break, and then we will continue with other speakers on the schedule. But there is something that
I would like to add one thing concerning the first question asked: why United States of America needs support from the countries that does not have space technology or does not participate in any other manner in space-related activities. That's because they need strong political support in order to provide new solutions. There is a great debate before the committee on the peaceful use of outer space, and also in the fourth committee. There's a special political committee. You know, we are speaking here about legal issues, and legal issues are reserved for the sixth committee in the United Nations General Assembly. but it is relocated to the special political committee. Special interests are involved in this process because international space law is still not yet well developed. And new solutions need to be presented before the committees, before the various other bodies. If one party, one major space power has a huge political support of the countries, whether they have or do not have space technology, that's some kind of advantage, and they can say that, for example, those accords are in line with the international law. We gain support from many other, let's say, partners, even if they do not participate in the Artemis program or any other space program. So that's a political reason and political method, and this method is, let's say, old method. That's this is not something that is new or surprising. That's very well expected.
I'm sorry if you do not mind, I would comment that it was also used within the negotiations of the Moon Treaty. However, the United States and Soviet Union decided to stay against. It has a history why they accepted the text of the Moon Treaty. It is a political issue, of course, and old method.
Politics creates the law.
Yes. And in addition, I would say, of course, I support the view of my colleague, fully support. The political reliance, the political union is really a great advantage. For instance, if we say that there are differences in Artemis Accord approach on the one hand, and on the other, the Outer Space Treaty of 1967 approach on the other, of course, the United States, bearing in mind that more than 100 states are parties to the Outer Space Treaty and not more than 30 states are parties to Artemis Accords, the United States, having such a political advantage, as my colleague correctly noted, the United States might say that, you see, among partners of the Artemis Accord are developed states, developing states, and so on and so forth. That is really a political advantage. As for the participation of the Soviet Union and United States of America in negotiating of the Moon Agreement, of course, there were reasons why both these countries negotiated, and there were reasons why they decided not to ratify this agreement, not to sign this agreement. In fact, the concept of the common heritage of mankind, which is reflected in the Moon Agreement, as my colleague correctly noted, this is, I would say, a concept which have both negative and positive, I would say, assessments, and taken into account how this concept of common heritage of mankind is realized in the law of the sea, it might not be very, I would say, astonishing to note that states today have some, I would say, reservedness regarding this concept, regarding the realization of this concept. In addition to this, as you know, there are more than a dozen of states which do not participate in the law of the sea, that is, in the concept of common heritage of mankind as it is applied to the natural resources of the seabed. And these states have their own understanding how to exploit natural resources of the area beyond national jurisdiction, disregarding what this international bureaucracy is taking decisions, what this authority, which is provided by United Nations Convention on the Law of the Sea. So it really a sensitive issue of law and policy. Thank you.
Good morning. My name is Milan Stojanovic. I'm coming from Astronomical Observatory of Belgrade. So we talked a lot about the United States, but I would like to shift a little bit this subject because I know that Serbia has signed the Memorandum of Understanding for the peaceful use of space treaty with Russia and with China. And I think these two memorandums of understanding are very important for the scientific community, which I'm representing here. I was intending to ask you, how is the policy for the decision making, the policy in Serbia to reach the point where we can fund the space agency, like it was done in, for example, Romania or whatever other country around our neighbors mainly. So I think that this is important issue for our government, the funding of the space agency, and I'm just asking you, how do you think these memorandums of understanding and the will to cooperate between these these big countries can lead maybe to funding of the space agency in Serbia? Thank you.
I'm afraid that I was not able to. I was not in position to read this memorandum. The first time I hear about the very existence of this memorandum with the memorandum of understanding with the Russian Federation and China, and I pose that these memorandum are in accordance with the space treaty. But concerning your concrete question and about the funding in International Space Agency, I'm not aware that this issue is currently on the agenda of the present government. So we have to understand we are a landlocked country, we are the country with too many problems and too many financial difficulties. And the issue needs to be raised by those institutions who are mostly interested in. Not to wait impulse or initiative from the government, but scientific institutions need to be the one who make those initiatives, and then when the question go into the procedure, then some funds will be found. If there is no such initiative, no funds.
Thank you. That is, how to say, exactly what I was expecting to hear, because a little bit later I will talk about some projects that we intend to develop at the Astronomical Observatory and to actually start some kind of space program here. And as soon as we are ready to do this, we will, of course, ask for our government for the support.
As in any other area, dissemination of proper informations are necessary in order to conduct proper activities of the government, of the various ministries, Ministry of Foreign Affairs, etc., etc. So please make those informations really available, not only on your websites, but inform the other participants, those people who are interested, convey some conferences or some meetings at which those issues will be discussed, and then the program can develop further.
Okay, thank you. Any other questions? Okay, I have a series of questions, but sorry, I had to put on the mic. Okay, I have a series of questions, and that's the fact that I have a series of questions stems from the fact that this domain is outside of the scope of my scientific interest, I have to admit. So my questions will be a kind of a common sense questions, and maybe they might look naive. So I will give you a series of questions, and if you consider some of them that they do not deserve any answer, don't answer, and just choose out of the list those that you find interesting. Some of them have been already dealt with partly, and just well, I, at least myself, need an additional clarification, and some of them cannot be dealt with. So I will give the whole list of questions, and so you choose. Okay, please. Okay, so you mentioned that, okay, those resources are common heritage of mankind, and that as far as the marine resources are concerned, there is the agreement of 1984, if I remember well, so which develops legal regime about it. So for the celestial bodies, for those resources, there is in fact a lacuna. So how is it filled? Is it, and has there been any need to fill it so far? Is it analogy with those? Is it possible to make an analogy? That is the first question, filling the lacuna. The second is those instruments that have been mentioned are interstate instruments, international, classical. So usually the provisions are states can. So the states are the parties, and they have rights and duties that stem from the provisions of the. There is a tendency, in fact, that private entities or even individuals take part in those research activity, and probably they will intend to take part in the use of those resources or exploitation of those resources. There is Elon Musk, who sends whatever it is called to the space. So what is the transmission from the international instruments to what those individuals can do? Obviously, you mentioned the American Act and the provisions that sound like they will be authorized to, etc. So is that the transmission, and is there a risk, if there are many transmissions of that kind, that there is a collision between those transmissions, and that perhaps it could create a chaos? Then the young colleague there, he put the question, which is about those who can and those who cannot. We are those who cannot, for instance, Serbia, and there is, let's say, Romania, who is more active legally, and they belong to those who cannot. Are there sufficient, let's say, kind of safeguards for those who cannot? Because if there is something is common heritage of mankind, and I am a part of the mankind, and I cannot reach the common heritage that belongs to me also.
The benefits
of it. So, yeah, are there any safeguards? So because there are some who can get. And then the question which is related to that is the safety zones that you may mention. So that sounds like a kind of an occupation. You just declare something your safe zone because you can reach it, and so that is my safety zone. First, the meaning of the term safety. Is it physical safety? So I need it in order to carry out what I'm doing there, or is it related rather to the possession, so safety of that kind. I cannot say property, but by the possession. And is it a little bit? Does that lead also to kind of let's say unjust treatment of those resources? And since my colleague, there are two colleagues of ours here from the Belgrade Law Faculty who are dealing with ecology, I think they might have some questions also later, perhaps. But a vast series of questions is open concerning the ecology, because we are, as human beings, we are very inclined to polluting whatever we can pollute. So what's the situation with that? Okay, thank you. This is a series of questions. They are probably quite naive or common sense questions, but okay, it's up to you as an expert, as experts, to choose out of this a la carte list. Would you like first or me?
Okay. Thank you. First, about the ecology, about the debris in the outer space, we shall have in our conference the specific report from our. I understand that Mr. Uvarov, who is graduated from MGIMO University, but now he works in the Russian Parliament, and he has prepared the specific report regarding ecological issues of the outer space. Probably we shall leave this question to him. I'm sure that he is online with us. As for other questions, all questions are interesting, of course, and as usually, I suggest that my young colleague, Dr. Mariam Yuzbashyan, starts with answering. Mariam? We do not hear you. Mm-hmm. Yes.
Thank you very much. I hope that this time I've heard right questions. I'm so sorry. As to safety zones, should I answer to this question?
Yes.
Yeah. As to safety zones, yes, it could become an de facto occupation. Because the free access to any region of any area of celestial bodies couldn't be provided when there are some kind of safety zones under the Artemis Accords. These safety zones are created for future exploration of space resources. However, it might contradict the Outer Space Treaty's principles. The main of which is the free access, providing free access to any area of a celestial body. As to other questions, I didn't heard well about the transmission issue. Is it a technical issue or a kind of?
No, it's a legal issue. The transmission from the state, there are duties and rights of states, and there are private.
Regarding the transmission.
Yeah. Okay. Can I repeat the question? Since those international instruments, they give rights and duties to states as parties, and then there is a tendency that some private entities or individuals take part in the research, and I think they also had probably the will and the wish to exploit the natural resources. So what is the legal transmission? Is it the national instruments like the American act that was mentioned? And is there a risk if there is a whole series of national instruments that might regulate that transmission in a different manner, that there is a chaos and that there is a collision between those regimes that might be established on that?
The national one, thank you very much. The national one and the applicable international one to all space activities. Do I understand right your question regarding the trend of commercialization and privatization of space activities and their regulation? Would this transmission on a legal level become a problem. Do I understand right the question? Yes, thank you very much. So this trend is not new. Commercial space activities are not prohibited by the Outer Space Treaty. Even the issues of responsibility and liability under the Outer Space Treaty and the whole regime of international space law do provide the general issues for regulation of private space activities within the framework of the national laws. These issues include the issues of authorization of space activities, because as it was mentioned in our discussion in the keynote presentations, that the states are responsible for the provision that all space activities are executed with in compliance with the Outer Space Treaty principles. So the states under national laws have the right to regulate these issues, to authorize space activities, so that they guarantee that these activities comply with the principles and provisions of established by the Outer Space Treaty. Do we have some problems? The one problem is the example that we discuss now. For example, the space resources. Space resources exploitation, future exploitation, is not regulated by international space law, specifically regulated. And when this issue is regulated by national laws, we could come to some disputes or misunderstanding, not the possibility to come to a common decision, consensus within the framework of the UN COPOS. As to, maybe I would stop and would you please ask something else? I would be happy to comment if it is possible.
Okay, thank you. So I put some other questions to it. Yeah. Okay. About the filling the lacuna in the notion concerning the notion and the common heritage of mankind, and well, the fact that marine resources that's regulated more in detail, while the celestial body resources are it's empty. So how do we feel it?
It is. Should I answer, Aleksandar Nikolaevich? It is empty. It has no determination. It is not determined under international space law. And the Moon Treaty that established this principle regarding the Moon and its resources provides for the establishment of international regime as soon as the space resources mining becomes feasible. But the conference that would establish such an international regime hasn't been convened until now. And with the execution of the Artemis, conclusion of Artemis Accords, some of the parties of the Moon Treaty even withdrew of the Moon Treaty, such as Saudi Arabia. And I don't think that the Moon Treaty has a future. This is my personal view. And the concept of common heritage of mankind within the framework of space resources mining would be supported in a de facto exploitation, unfortunately. But there is another important concept, the province of all mankind, that is included in the Outer Space Treaty. And the Outer Space Treaty provides that the use and investigation, exploration of the outer space, and including celestial bodies, is the province of all mankind. It is important for all states, for all parties. And it has more, it could be supported by future regime, but common heritage of mankind, I think, would not be supported. and it hasn't been determined.
Just one addition, and afterwards you. Could you? Yeah, thank you. Just one addition to what Dr. Mariam Yuzbashyan has already said. Yes, we think that the common heritage of mankind concept, which is provided by the Moon Agreement, does not have future. That is certain. What about the another wording, the province of all mankind? These wording are reflected in the Outer Space Treaty, and this is already a part of international law. And the United States of America are parties to the treaty. Russia is a party of the, and Yugoslavia was a party. Yeah. I agree with the issue that sometimes treaties are useful, but sometimes we forget about the importance of this issue. And during the previous conference, I recall that Yugoslavia was a part of the Spitsbergen Treaty of 1920, and Serbia does not have time probably to look at it.
Few months ago, we deposited an instrument of ratification,
so
we are now party of that.
Great,
treaty.
congratulations! Yes, so you see, it's a process. It's a sort of, it's not a static picture. It's a dynamic picture, and so I think that the problem is that whatever words you are using, the province of all mankind or the common heritage of mankind, the problem is that as for the legal regime of natural resources, of celestial bodies, neither of two wordings, neither of two formulas are realized. And as we told, there is no common heritage mechanism. And of course there is the province of all mechanism, and we do not see whether these are different words, just to say that no, we have nothing to do with this common heritage mechanism which is provided by UNCLOS, and we have nothing to do with all these negative issues which are, so to say, which we feel, which will look today. The mechanism of the province of all mankind is not created, and practically we do not know what does it mean in practical terms. So I think that still there are questions and there are no answers yet as for this. Yes, I think the issue of Elon Musk and responsibilities of states is really very, very important, because we understand that the private entities are more and more active in outer space activity nowadays, but only states are subjects of international law, not private persons, of course. And of course we understand that the activity might be carried out in outer space by private entities, but the regulation will always be the monopoly of states, not by private persons. Otherwise, it will not be international law. Thank you.
But there is, for instance, there is a clear example, recent, well known. Elon Musk, obviously the United States of America would like to use his Starlink, or whatever it is called, for spying upon what is happening in Ukraine, in Donbass, etc., etc. Yeah. And he sometimes says yes, sometimes says no. So he has a kind of a final say of what will be done. So where is that is an issue which is probably has some legal, since the states are parties to everything. So he sent those satellites to the space as a kind of, I don't know in what status, as a kind of a state agent, or as an individual who's authorized by the state or whatever. But obviously he has some freedom and he's independent from the state. So that is. I think that is a complex issue, and I don't know whether it is legally covered.
I agree that this is a complex issue, and I think that Elon Musk is acting on the basis, of course, the national legislation of the United States. According to the Outer Space Treaty, if something happens which causes some, say, negative results, it is the United States, according to the Outer Space Treaty of 1970, yes, has responsibility. Thank you.
And also liability issues. I'm sorry. Also liability issues are important because states provide indemnification of damage caused by space object, even if that damage was caused by objects, for example, in ownership of private parties, including Elon Musk's objects.
So the United
Yes.
States are liable. Thank you.
Yes, probably.
And Branko, you put very serious questions. The first one concerning the incomplete, let's say, that international space law has many lacunas. Yeah, there are many lacunas. They're still have to be developed, but not by analogy. Analogy will lead to, I said, maybe wrong results, and if we go by analogy, then every state will create its own regime, and that will be the complete chaos. Those questions you put are under consideration of the Scientific and Technical Committee and the committee and the legal subcommittee of the Committee of Peaceful Use of Outer Space. And the debate is, let's say, very comprehensive, and very different views about those questions are, those issues are presented during the debates. I had opportunity to read those debates in preparation for this conference, and let's say it's very, very hard to find the minimum that is necessary for the creation of some complete legal regime of outer space and its resources. Of course, states, particularly main state actors such as the United States of America, use this as an opportunity to develop its own solutions to the problem. And if first the one who developed this and implement that in practice is in the great advantage, because there is no international mechanism to stop them. Of course, there is no some judicial authority, and if we want to say let's create some comprehensive legal regime by way of interpretation, by way of analogy, that will be just a theoretical work maybe of great academic importance, but of very, very little practical value. Because when the state wants to create, when the state negotiate, they put on the paper what is in their interests. If they want some complete legal regime, they will easily call a few professors, they will create that perfectly. But states does not want that. They want to protect their own interests. You ask about those spy technologies, etc., etc. They had this spy technology in 1995, as soon as I know, because we were both involved in the work of the International Criminal Tribunal for the former Yugoslavia, but satellite pictures and etc. that was available at that time. Now I only can imagine about the development of that technology. And concerning this, you ask about those safety zones or safeguards, etc., etc.
And those are two different questions.
I think safety zones. Yeah, I think that was by, let's say, by analogy with the United Nations Convention on the Law of the Sea. And there is one more method of, let's say, filling lacuna in international space law. That's by way of issuing guidelines. For example, recently guidelines for the long-term sustainability of outer space activities were adopted by the relevant committee of the United Nations. And of course there is some guidelines concerning debris, but there is always a question. While the General Assembly said, okay, we welcome the issuance of those guidelines and attempt of the state to implement those guidelines, whether those guidelines, can those guidelines be interpreted in the way that is not always consistent with the Outer Space Treaty? There were also some attempts to do that by certain space actors. So we are here dealing with the very, very complicated questions that are complicated issues that are in phase of the development, and interests of states are great, but the things are going very, very slow. And I think in the years that follows, the discussion will always repeat the same questions, and the scientific and technical committee will note further developments, but the legal development will be, let's say, insufficient. That's my prediction.
And just before the coffee break, because now we have a coffee break, and it will take place in the Professors Club here, so you're all invited. Just a little bit my question that I already put, I will simplify it and vulgarize it. And the question about those who can, those who cannot, and are there any guarantees, any safeguards for us, the poor ones who are. So I just learned from your interventions that there are some asteroids or whatever when there is a lot of silver, and that is a rich resource, and I also learned that it belongs partly to me also. Yeah, it's a common heritage of mankind and a part of the mankind, although directly or via my state, it doesn't matter, as a greedy person, I'm just worried about the fact how to
get your
have
share.
Some benefits of that silver. I would like to have something. And are there in the international law or national law, are there any guarantees for me? Especially I'm a Serb, so I cannot reach it. Perhaps you're in a better position as a Russian. Yeah. Okay, so is there an answer to my poor self?
Well, I think cooperation is a key for this, and I think that United States has already chosen in its partners, and just trying to have not only Western countries, but from Arab states, those who do not have technical capabilities to launch their satellite, for instance, but those who have money. And by attracting investments, United States, basing on this legal approach, national laws plus Artemida Accords, in fact written as just a mixture between the wording of the outer space treaties and the wording of their national laws. And so I think that the most available way for Serbia, for you, of course, is to speak for cooperation with Russia, of course. Sure. Thank you.
So from the American point of view, in fact, in their model, you cannot, although we have it, we do not have it, we can only pay it. We can buy it, isn't it? So those Arab states, they buy it. So I could go to the first goldsmith and buy my silver instead of financing, investing into it. Okay, thank you. So, ladies and gentlemen, the coffee break. And we continue here at 11:30.